Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us my law partner David Nachman. David, welcome.
Thanks so much, Michael.
Now, if you guys have been watching our program for the previous couple of programs, we have been discussing about the new Visa Bulletin under which some people can apply 485 application and get benefits under that, we talked a lot about that. But if anybody has any requests for information, we feel free to send us an email and we'll be more than happy to provide you. Couple of things I want to talk about before I give to David about your chances is the question that we talked about in the first program was why so? What was the reason behind, which David explained nicely. I want to add something. You see, our Oppenheimer, who is the officer in charge in the Department of State, who monthly basis decide, he was always concerned about the wasting the visa numbers. Every month American consulates and the immigration service request the Department of State to give us so many numbers. So what they were doing, they are getting the numbers and not using them. And remember in 2007, he got very upset. He said, okay, hell with it. We were actually in a LR conference. He said, all employment categories current.
And then he went on vacation.
He went on vacation. So
no one could reach him.
Every single person, thousands of applications, people filed 485. It was current. And the law says if your visa number is available, file the 485.
And no immigration lawyers were in the office because when the phones were ringing.
So after that, a lot of people filed, they got EADs, they got a permission to travel, but they had to wait until the visa number became available. By this time, all those cases have been resolved almost. So this is one of the other reasons that he's always concerned about. So one of the reasons is this will push them. In other words, we file the 485 in advance. So file is already in the immigration office, right? Everything is there. Once the visa number becomes available, they just pull those files and issue the visas. This way, there is very less likelihood. Same thing they are going to do with the Department of State. They are encouraging people to complete their cases so that the Department of State, the National Visa Center, has a completed file. And then when they say, request them how many numbers you need, they look at all the complete file. I need 1200 numbers for this. And those numbers can be utilized because they already have the file ready to go. So I think this was, in my opinion, the main reason why they wanted to modernize or to make it easier. With regard to the Department of State, also same thing. The National Visa Center completes all the files. They have already 112 files or whatever, 500 files ready to go. They give 500 numbers and they just schedule interviews right away. They don't have to wait back and forth, give me this document, give me that document, waste a lot of time. Before that, the October the numbers run out. So I think technically a very good idea. This is a nice idea so that we don't waste any visa numbers. Every single visa number is used up. Exactly. Besides that, there is some political thing also. I know a lot of our clients and friends, especially in California, their companies also said that these people that are working in our company, especially you are talking about EB2 category, they have to wait so many years to file a 485. They have been pushing them hard. This will also satisfy many of our, especially you know how many IT people our Indians are in waiting for that. So if anybody has a 2008, 2009 cutoff visa number available at priority date, they can go ahead and file 485. They don't have to wait another 3 years, 4 years. So these were some of the reasons. One other item I want to say, this is not for everybody. Please make sure that we want to say this is for only people that are physically living in the US. Adjustment of status can only be done if your relative, if your friend or who we are talking about is physically here in the US. It cannot, that doesn't help the consular processing in India or any other place. And you have to be eligible for it to file. It's not that any person who's illegal here can file it. So if person is maintaining the legal status, then you can use this filing. Or the person is a 245I which had filed before April 2001, that person may be able to file, but not everybody, not a person who is illegally residing. He might have a labor certification, he might even have an I-140 approved, but he won't be able to file 485. You have to meet the requirements for filing. David.
Exactly. Well, Michael, I think that you just made really one of the most important points about the new Visa Bulletin, and that is that the people who are going to benefit are the folks who are here in the United States, who are filing for their adjustment of status applications, because again, they'll be getting work authorization, they'll be getting advanced parole travel documents, They'll be getting the ability to take advantage of AC-21 mobility. So under section 106C. So I'm so sorry. Yeah, because as a lawyer, I always speak in acronyms without explaining fully what that means. But for those of you who are, some of you might be aware of what it means. There are a certain number of criteria that need to be satisfied in order for an individual to be able to move to a new place of employment when they have a perm labor certification. Essentially what happens is under AC-21, the government gave you the right to, it's actually a property right that the individual gets, the beneficiary gets, in the perm labor certification. So in a labor certification process, generally the employer drives the process. However, what they did is they unshackled the employer and the employee at a certain point in the process, and that's what's called AC-21 mobility under Section 106C. So what that does is that if a perm labor certification application is approved, an I-140 has been approved, an I-485 has been filed, and it's been pending for 180 days, and the individual is moving to a new position in the same or similar occupation, and that's open to some subjective determination, but generally if an individual, for example, is an IT professional and they're going on to become a database manager or a systems analyst somewhere else, or they're going to teach IT somewhere, those are considered same or similar occupation. An individual gets a personal property right in that labor certification, and they don't have to stay at the same place of employment, so they can move to a new place of employment. It's a really wonderful benefit that was conferred under AC-21, but there are some procedural nuances with regard to proving in the adjustment of status process that the individual is in the same or similar occupation.
What David actually explained is that you can utilize this AC-21 only after you have filed the 485 and you have been more than 180 years, still this keeps pending. And it keeps pending because visa numbers are not available many times.
But what's nice about the new Visa Bulletin is that now you can file that 485 in advance of the priority date. Exactly.
So that's another benefit.
Exactly. So that's another benefit.
Okay, one thing, I think a lot of people have this question on mind. I don't want to just keep that pending for the next program. Child Status Protection Act. Children that left behind because they aged out. Now, in the old times before the CSPA, if the child was 21 years and 1 day, that's it. Not getting the visa, arriving in the US. You must reach here before you hit 21. So there were a lot of complaints that immigration service is kind of delaying 2 to 3, 4 years. So what's not our fault? So then they came with this new idea. Okay, fine. What we'll do from now onwards, we will calculate the amount of time that immigration took in approving your petition. And when the visa number becomes available, we look at the age of the child. Let us say the age of the child is 23 years, but immigration took 4 years to approve. You minus 4 years from the age and the child goes back under the 20. It's a very good program. But this won't benefit, because I don't think so, because the Child Status Protection Act is a law made by the Congress. So I don't think this is not a question of filing here, it's a question of changing the law. So that, in my opinion, but we have to wait to see what they do on this. As David said, we will be getting a lot of emails and questions and going forward in the next few months, and we'll come back to you. Some of these things we just, as David says, that some of these things we are guessing based on best experience. Although I think we have a lot of experience, so I would say 90% chances that this is going to happen.
Right, but I think the most important issue on the Child Status Protection Act, Michael, you and I were discussing the other day, and that is that it really has to do with the calculation of how long the I-130 is pending, or the I-140, and then you back it out. So what does that have to do with the application? It's really more the petition that's relevant.
Yes.
So I think that that's really where the CSPA shakes out on this issue, but yeah.
So now a couple of things about the travel. You want to talk about travel? Why people should be concerned about?
Well, let's first talk about the medical exam, so that I think it's important, because a lot of our viewers, of course, they have to go out and they have to do medical exams, and some of them are going to be right now looking at these visa bulletins, and they're going to be calling their lawyers, and they're going to be saying, hey, I have to file, and then their lawyer is going to give them a standard list of documents. right, and not giving any thought to it, they're going to run off and start doing medicals. Should they do their medical exams or not?
There has to be a policy decision. This question definitely is going to be raised by our ALA to see if you either eliminate that. They say once you file the medical report, it's good for,
Well, what's the rule? The rule right now is that the medical reports are good for 1 year.
Yes.
And if we know that that 1 year is going to lapse before the priority date actually becomes current, then a lot of people who do those earlier filings potentially could lose the validity of those medical reports. So
same thing is about the affidavit of support, 864. Exactly. It's required to be filed together with the 485 application, right? And again, after 1 year, they may have to submit more documents and all that. I have a feeling that it's possible that because of this thing happening, they may just accept whatever is initially filed and not are required to go back and again, basically. They do their search anyway about any.
Well, they may have to go back and they may have to put out a new guideline, because that's what it's going to be. It's not going to be a rule. It's probably going to be some type of guideline that allows for the medicals to be valid, notwithstanding the fact that they were filed as with adjustments on those earlier dates, with those filing dates. So it's going to be interesting to see what they end up doing. But right now, we're telling our clients not to file the medicals and to wait, because we know that in the adjustment of status process, when they don't see a medical report, okay, what they'll do is they'll submit an RFE and they'll ask for the medical report, so you can send the medical report back. Now, a lot of our clients then ask, well, we don't want to get the RFE because the RFE might slow the process down. Yes, yes. But, from experience, what I can say is when an RFE does come, and it's a simple RFE like that one, and it's only the medical report, and all you're doing is resubmitting the medical report, it brings the case to the top of the pile, and hopefully it moves right through the process. So I don't see it as being a bad thing, but I'm sure that many of my colleagues might disagree with me.
Some people say, oh, these are good things. This is nice, this thing to happen. Why don't they do like this? Why don't they issue the green card earlier? Why not this? Why not that? And we did mention in one of the programs that president does not have the authority to change the law. Now, this thing is only filing. Like any other changes like they made when that provisional waiver thing came in, you had to file a waiver only abroad at the American Consulate. It changed it. So you can file in the US also. So changing the place where you filed is not a law. It's basically up to the administration in terms of administratively. They say by file here rather than there. That's not the law. So they don't need the consent of the Congress or permission of the Congress. Similarly here, all they are saying, you can file it little earlier. So I don't think in the law anywhere it says you can only file it after the visa number becomes up. That has been a policy, in my opinion. However, thought came to my mind. Does it prevent these conservative Republicans to go to the court again and file a case saying that this is not right because that's not the law, or there's a violation? Anything can happen. Listen, this is America, my friend. America, you can sue anybody for anything. I was a lawyer in the Bhopal gas case, and Union Carbide filed a suit against Union Carbide for $100 billion. David, I didn't know how to write. I called a CPA to give me how many zeros. Sure. So this is possible, but then how the courts decide is always possible. They stayed out of the DACA and the DAPA, right? So we are prepared. We are ready.
Actually, I'm glad you brought that up, because we have the DACA and DAPA issue that's still in abeyance right now, and we're waiting for the courts to act on that. And another question that we're getting frequently from our viewers has to do with the STEM extensions, because that right now is also the subject of a court action in Washington, D.C., where an action was brought saying that the STEM extensions were improper. So we're waiting for the government now to issue a new rule, because there has to be a rule to deal with STEM extensions. So that's something we're waiting on also. As soon as we have that information, of course, we're going to do our very best to give that information to our viewers as quickly as possible.
We got a signal from our director of photography that time is up. We got to bring this program to a conclusion today. But we still have certain questions left that we will probably cover in our next program. So make sure to watch us on every Saturday and Sunday at 11:45 a.m. Thank you very much for watching the program, and thank you, David, for coming on
Thanks
the
so
program.
much, Michael.
And goodbye.